May it please the court, Michael Mervon on behalf of the state. The state would request 2 minutes rebuttal time, if possible. The state in this case, Your Honors, is requesting that this court overturn the lower court's granting of the defense motion to suppress. In this case, the sheriff's office obtained a judicially approved search.
What evidence was suppressed? Was it everything that was recovered?
Everything.
Everything from when the sheriff got there as well as when the code enforcement got there?
Correct, Your Honor. And that's the heart of the state's argument, because according to the record, the code enforcement officer was not contacted until the sheriff's office had completed their search and had collected all of the contraband, which included marijuana and some paraphernalia.
Frankly, what right did the sheriff's office have to contact law enforcement and give them access to that property?
They didn't, Your Honor. However, the exclusionary rule wouldn't be the appropriate way to address that mistake.
I understand how the exclusionary rule works, but tell me, what would be the appropriate remedy under these circumstances for the defendant?
Perhaps a civil lawsuit under Section 1984, a violation of privacy, a violation of due process based upon the actions of the police.
And I understand the Second District has previously excluded all evidence in connection with a search. I don't recall the exact facts of that case at this moment, but if the action is what the officers did in this case sufficiently egregious to apply the exclusionary rule under these circumstances?
No, Your Honor. There have been cases where perhaps television crews or private detectives have accompanied police during the execution of the search warrant, and under the theory that wrongdoing could directly or indirectly lead to the seizure of the contraband, those have been held improper and subject to the exclusionary rule.
Your argument would be different, of course, if they had brought the code enforcement officer along with them in the initial search.
Yes, Your Honor. We wouldn't have a very good argument in that case because the code enforcement wasn't listed as any of the participating agencies in the execution of the
And just so I'm clear, nothing that the code enforcement found was relevant to what was needed to prosecute in this case. In other words, I understand there's an outboard motor and a couple other things from what I could determine. Mm-hmm. And my point is, the sheriff's office had already sequestered or taken, pursuant to the search warrant, what they needed. The code enforcement officer was called. Court enforcement officer comes in, does a search, motion to suppress, the court suppresses everything.
Correct, Your Honor. And in doing so, the trial court cited a Sixth Circuit case, a federal case, and in that case, the police were executing a search warrant, and they brought along with them a private detective from Ford Motor Company who had an interest in perhaps stolen property by the subject of the search warrant.
But that was a civil case, wasn't it?
It was, Your Honor, and the court made its decision pursuant to I believe, a motion. It's been a long time since I've had civil law. A summary judgment. So that was the context of that ruling. But just to wrap it up, citing Wansong as well as Hudson, the Supreme Court has been pretty consistent that the exclusionary rule is only applicable to property to contraband which has been seized pursuant to the illegality of the police conduct. And again, in this circumstance, it was a judicially approved search warrant, and anything which occurred with this code enforcement officer was after the execution of the search warrant.
And I think the question was asked, I just want to confirm the answer. The findings by the court enforcement officer, none of those resulted in criminal charges against the defendant, or did they?
I'm unaware that they definitely weren't attached to this case involving the possession of the drugs. It's not part of the record what the actual violations of the code were. I believe in the argument in the summary judgment hearing, there was an allegation that an extension cord was leading to a hut and therefore providing electricity in violation of some sort of municipal code. Again, we would ask that the court reverse the circuit court's granting of suppression motion.
Thank you, counsel.
Counsel?
Good morning, Your Honor. Mark Cole on behalf of Mr. Marr. I don't have a whole lot to say. Basically, I think the judge wrote a very good order, and my client would be happy with the PCA.
What exactly was my concern is what's being suppressed. Was anything, did the code enforcement officer find anything?
The code enforcement officer did find things and instituted a code enforcement violation.
But code enforcement?
That was done through code enforcement,
Right.
and it was all handled non-judicially.
Okay.
My client
I got
complied
you.
with whatever it is that they
I
requested,
got you.
paid money. I don't know what exactly it was. He came to me, and I told him I don't do that kind of work.
Understand.
It was handled completely independent of this particular case. This case, what was suppressed was all the evidence that was seized by the law enforcement, including the evidence that was not contraband, the things that the officer stole from my client.
Right.
What was like weapons, the ledgers?
The outboard motor.
The what?
Outboard motor.
$231 in cash.
That was from the code enforcement officer, right?
No.
No, that was from
That was the police.
There was a $231 paper clip to an electric bill that was sitting on the counter when they did the search.
When you say it's stolen by the police, what exactly?
The $231 is not contraband. There's no
But
evidence.
it's not missing.
Oh, no, it's sitting in property.
Okay, now
it
let
has
me-
been since the day of the
I got you. I just want to make sure. I want to make sure.
No officer put it in his pocket.
Put it in the
No.
pocket and walk off with it. Okay.
But there is actually a statute out there that says an officer that exceeds the scope of the search warrant is liable for the crime of theft.
Exactly.
You know, my client, one of my rules is that before you try and skin the bear, you get your hand out of the bear's mouth. So I told my client to hold back on doing anything as far as that's concerned until we're done with this.
Thank you, counsel.
Thank you, Counsel.
Thank you, Mr.
And
Holmes.
that's
Mr. Mervine, anything else?
Thank you both.
We are adjourned.